You're watching the Breakfast Show on TVC. Now, former PDP spokesman Metuh collapsed at the Federal High Court in Abuja on Monday. Metuh was making his way to the dock for his resumed trial when he slumped.
Now, Justice Okonabang had to stand down the matter to enable medical officials attend to him. And the judge ruled that the trial would go on, but counsel to Metuh, Emeka Etiaba, argued that he can't continue with the proceedings because his client laid on a stretcher. But the judge refused Etiaba's withdrawal and adjourned the case to May 22nd for cross-examination of the 11th witness. Metuh is being prosecuted by the EFCC for allegedly receiving 400 million naira from the Office of the National Security Advisor, Sambo Dasuki, in 2014.
2 steps away from the dock was where he sat. He had made a second step. It was just for him to enter the dock, and he now turned because he now had the judge saying, go back and sit. As he was turning, what I now found was that he was on the floor. Medical personnel from the Federal High Court was invited, and 2 nurses and a medical doctor came in at the instance of the court. The court registrar invited them, and all this while Chief Metuh was on the floor. And he was actually in pain, shouting, and the doctors examined him. And as they were still examining him, the court made its way back to court.
I owe this trial the highest sense of responsibility as a prosecutor. The Administration of Criminal Justice Act is clear. A defendant can only stand trial while he's before the court. Now, if the medical personnel had said or given an opinion to the Honorable Court that he needed to be evacuated to the hospital, and I'm asked to comment, what would I say naturally? Going by the law, I would have to say I'm not opposed. More so that the case is adjourned for tomorrow. So my view is that they can go and check him. We come back tomorrow. We continue with the trial.
And that tomorrow is today, today being Tuesday. So we will be bringing up updates as to how things play out in court if the case holds today. Now, we have a lawyer and public affairs analyst, Wale Fakponda, joining us in the studio. Wale, good morning.
Good morning. Good
nice to see you.
Yes, good to see you.
Now, first of all, what do you make of the lingering trial? There seemed to be going on adjournment upon adjournment on the Metuh case. It's been on for a year. So long.
Well, the starting point is this. I think Metuh and his team of lawyers haven't understood that it may be difficult for them to put up a viable defense in this charge against him. Decided to look for different delay tactics and buying time just to see whether some kind of underhand negotiation can go on. Because clearly, if you look at it, this journey started from when this matter was instituted. At first, there was an objection. There was a technical objection that the Federal High Court do not have the jurisdiction to entertain count 1 and 2 of the charge against him. That technical objection went up all the way to the Supreme Court. Now, the Supreme Court actually scolded the lawyer and said, although you have the right under Section 396, Section 2 of the Administration of Criminal Justice Act to raise objection regarding jurisdiction, but such objection must be heard with the substantive matter so that we don't waste time, so that when the court is giving its decision regarding the substantive matter, it can also rule on your objection. And the court actually said, Justice Akas actually said that this is a storm in the teacup and actually warned the lawyer. Now, that did not work. They came up again after the prosecution closed this case. They came up again on a no-case submission. And then that also went to the Supreme Court. And the Supreme Court said, look, under Section 223, subsection 2 of the 1999 Constitution, you need the leave of courts to appeal grants of appeal that is of mixed facts and law.
Okay.
And the court said, go back and go and face your trial. Now, Metuh has come up with several reasons not to defend this matter. There was a time he said Justice Okonabang was his classmate in law school, and because of that, he wasn't going to get a fair trial. You know, all kinds of reasons have come up. And then these days he's on stretcher, tomorrow he's on a wheelchair. This is someone that had the energy to face the EFCC detectives and tore the statement he made. We read it in the paper that he had a scuffle with them. He had the energy to do all of this. He had the energy to attend PDP convention and now to face trial. You know, every man must be responsible for the natural and probable consequences of his action. When he was collecting 400 million naira, nobody was there. So he should defend the matter.
Okay,
it's
now,
as simple as that.
Now, there's been a question of how really is he sick, or does he really need to see his doctors? Because we also know that the National Hospital has actually come out to say that he needs to see his doctor. Do you think that is totally unnecessary? He's just acting out?
I think this is, for lack of a better word, I think this is just Nollywood. I think this is theatrics. I don't believe him. I can see through the sinister motive. And the truth of the matter is this. I've given you his antecedents. The first point is, as a lawyer, we know the game, we know the trick. When you have a weak case, the first thing to do is to try to come up with legal and technical objections. And you go on appeal up to the Supreme Court, and then you come back. Now, because the courts in Nigeria buying into the anti-corruption agenda of the government can see their sinister motives. So that's why the court saying go and face your trial.
Yeah, but
so that's not working.
Yeah, but in that case, when he comes out to say he's not feeling well, the point there is there are procedures, there are hospitals that can test him to certify him okay or not. Even though he's requesting to go to travel to London or the UK for his medical attention.
Well, the hospital can test to determine whether indeed and in truth he's not feeling fine. But as a public affair analyst, and as a lawyer that knows the trick that goes on in the courtroom, and that knows the games that these people play, I don't believe him.
All right. Well, when it comes to the issue of ill health, anyone can fall ill. That's what anybody will say. It's just natural.
Yeah, but why is it happening now? This was somebody that had a struggle with EFCC officials. This was somebody that was well enough to attend PDP convention. So why is it now that you suddenly fell ill? Why is it up until you lost your interlocutory appeals at the Supreme Court in a bid to delay the case? So why is it now that you are falling ill and you are falling down, you're on a stretcher, you're on a wheelchair? You see, Nigeria, we love drama. We love drama. I don't believe, and rightfully, Justice Okonabang, knowing him very well, we have appeared before him a number of times when he was at the Lagos Division. He can see through this because he was also in the bar before he went to the bench. So he knows this game. And that's why he insisted that this trial must go on. You know, anybody can fall ill. But if you look at this man's track record, if you look at his antecedents, it is very difficult for you to convince anybody that this man is genuinely ill.
All right.
On what grounds can someone be actually granted that to be able to go get treatment?
No, if you are healed, if you are genuinely healed, and then there is a medical certification that you are healed, then, of course, it's only normal because it's only a dead man that can start trial. It's only a living man that can start trial. Okay? So it is only normal and it's only reasonable for them to allow you. But in this instance, it is totally different because certain things have transpired before now. And we are then saying, you are trying to buy time. You are wasting the time. There was a time they brought a release in the papers that he was ready to release the money that he submitted. You know, the government said, no, face your trial. So he has tried all he can try. And that's why he's now saying, you know what, let me pretend that I don't believe him.
Now that his lawyer has decided to withdraw, what's the implication?
He has a right to withdraw. He's a lawyer. He has a right to withdraw. That he has a right to say, you know what, I'm not representing again. Nobody's going to force him to do that. He has a right to say that. All right. But Metuh is also entitled to legal representation. If no lawyer is ready to take up his case, the government will give him a lawyer. But this trial must continue because there must be an end to impunity. There must be an end to stealing of government resources.
All right, let's see from the eyes of the EFCC. In fact, Justice Okonabang threatened to strike out the case when they came up with the issue of adjournment, and the EFCC lawyer agreed to it instead of objecting all of that.
That's the point I'm making. If you look at Justice Okonabang in this matter, he is more than ready to see
To
this
dispense
matter
with
to the
yeah.
logical conclusion, and everybody keeps wasting time. And that was why he was a bit infuriated with the EFCC prosecution. That why wouldn't you object? Because he felt the EFCC lawyer should be on the same page with him with respect to understanding the game at hand. And then for the EFCC lawyer to then say, well, I'm not objecting to an adjournment. Because truth of the matter is this, majority of Nigerians knows that this man is pretending. And so, to be very honest.
You can't ascertain that in scientific terms.
Well,
when it comes to medical terms.
Opinions,
He is the one who says, I am sick.
Opinions that we've read. I've told you the basis of my disbelief. And opinions that we've read, either in the newspaper or social media, everybody thinks you are playing games.
Except, of course, Governor Fayose, who doesn't believe he's playing games.
Yeah, well, Governor Fayose is in a world of his own. He's in a world of his own. And you know, Governor Fayose is anything anti-Buhari, anything anti this government. And so, as far as he's concerned, he doesn't. Governor Fayose's case is the enemy of my enemy is my friend. And so, but he has his own. He's going to have his day in court as well, you know, because the charges against him as there. The Court of Appeal has said that they should freeze that his account. He needs to also come and account for his share of the $2.1 billion that was meant to purchase arms for the fight of.
But his aides have said that all those are political persecution. In fact, that's some of these aides said is political persecution against
but the way EFCC was able to trade, you see, that is the essence of, that's the excitement about BVN and these innovations at the bank. The EFCC was able to trace inflows into his account. And so, you need to come and explain how $2.1 billion filtered and some part of it got into your account. It's as simple as that. So, like I said earlier, you need to face the natural and probable consequence of your action. So whether Governor Fayose likes it or not, he also has an explanation to make regarding that money. So I'm not surprised that he's supporting Olisa Metuh. He will, because he also need to explain how he got his own share and what.
But just as you said, the Nigerians believe he's acting. Many Nigerians also believe that the whole war against corruption is just targeted at some certain people, where there are other cases that's been reports of corruption and nobody's been investigating them.
What are those cases? I'm not aware of those cases that we are talking about here. Maybe we can give practical examples of cases of corruption, glaring cases of corruption that the EFCC has refused to take up.
Well, Sarah,
I'm coming, sir.
Yes.
I'm coming. Orji Uzor-Kalu is a member of APC.
Represents member of...
Well, he's a member. Just last week, the EFCC closed his case, and then the court said he should open his own case. He's a member of the APC. And show me anybody that the EFCC has arrested and are prosecuting today that did not...
We have the Secretary General, the former Secretary General of the Federation, who I asked that earlier, who was removed because of corruption, but we've not heard anything about his case.
Well, the EFCC will not charge you to court the next day after you were removed. There was an administrative panel set up by the president, and he was indicted. And I'm sure a report was transmitted to the EFCC. They still have to do their own investigation. You see, what we need to understand is this. Sometimes administrative misconduct may not amount to a crime. So that is what the EFCC need to establish against him. Now, if the EFCC establishes that you are, the former Secretary General of the
Secretary to the Government of the Federation,
yes, has committed an offense, then they will charge him to court for the offense that he has committed. But then again, we cannot also say, or we cannot also expect that the government should be 100% perfect in the fight against corruption. But one thing that I keep saying is this: mention one person that has been arrested and that is undergoing prosecution by the EFCC, that it is just framed up, that they just framed it up against the person. There's nobody. The records are there as to how the money moved.
Well, how the money moved, certainly, EFCC must have some cases before they follow up. But certainly, a lot of analysts have even come to say, well, we expect EFCC to do due diligence in investigations even before arresting. Now, Serap came up with a report saying that since 2000, about 177 real strong cases of corruption have been instituted. Only 10 convictions since 2000.
Yeah, that's what we're saying. This is part of the problem that we're having. They file a charge against you. You come up with legal and technical objections. You appeal that all the way to the Supreme Court. You come back. You come up with another objection. And then when that is not working, you begin to dramatize. How are you going to have conviction?
But that also brings us to the point of the special courts for corruption. Do you think that
absolutely, I think it's absolutely necessary. I think it's absolutely necessary that we be devoid of this procedural bottlenecks, that it is simply straight to the point. You come there, you have committed an offense, plead guilty, or you have pleaded not guilty, the trial goes on, and then we need to also, you see, the problem is this, there is so much growing tension between Section 36, that guarantees right to fair hearing, and the administration of criminal justice. Because the point that you make is, I have right to fair hearing. I have right to fair hearing. So you come up with an objection, and if the court overrules you, oh, it's a violation of my right to fair hearing, and you go on appeal. And then we know how long it takes for our appeal process in Nigeria. So SERAP needs to also look at the various bottlenecks that we have. And even we as a people, we have so many problems as a people. You see analysts, you see people that you're supposed to be looking up to in the society, supporting corrupt elements, and now, coming up with all kinds of arguments. Yes,
the president in the early days of this administration accused the judiciary of not doing well. In fact, I want to put it in the same way, of being the problem of corruption, as the case may be. Now, when we come to, we'll move forward. The court has granted a perpetual injunction against someone who was accused of corrupt practices before. When you come up, perpetual injunction, sometimes interlocutory injunction, we've had all of these issues.
That wasn't in this administration. That was not in this administration.
But it's the courts. The court remained the court.
Yes, it is the court. You see, the thing is this. The president may not being a lawyer, may not understand the real activities in the courts. So the president just feels that, oh, it is the judiciary that is my problem. Now, you have laws, you have rules of court that governs proceedings in courts. Okay? Now, people will then come with ulterior and sinister motives, try to rely on those technicalities just to stall matters. And the judiciary are untied. They can't, because it is clear in black and white what procedure they must follow. And so that's why the president may not have understood that, look, it's not necessarily the judges. Some of them, we have bad eggs, yes. Some of them, and then you see very fantastic job that the NJC is doing these days, recommending people for dismissal, sacking people, and all of that. Yes, we have bad eggs, you know, but at the same time, it is more of the various procedural bottlenecks, you know, that we have in the rules of court. Like you mentioned, the specialized court system is fantastic, and in our laws, you know, so that's exactly the real problem that we have. Not necessarily the judiciary. We have bad eggs, but there are a lot of. I mean, look at Justice Okonabang. There's Justice Latifat Okunu of the Lagos High Court. You know that when you get before that judge for a criminal matter, you are just buying time. If you are really guilty, you are buying time. You are going to jail. There's no doubt about it. Talking about the president understanding legal matters, do you think he understands the importance of obeying court orders in the case of Dasuki and Elzalsaki? What would you be your comment on that? Well, I'm not aware that there is any that Dasuki particularly is being held illegally. And Elzalsaki. I'm not aware that Zazaki may not be on all fours on the facts of that case, but I know of Dasuki that there have been various matters against him. It's not just the corruption matter. It's not just the $2.1 billion. Yeah, but should he be held? Should he be held indefinitely? No. There are also other matters. Yeah, but should he be held indefinitely, even if there are other matters? If I decide to commit multiple offenses, I have to answer for those offenses. If the court, in a charge of stealing, granted me bail, and I have decided, and there's also a charge of tax evasion against me, which is a criminal offense, and the court has not granted me bail in that matter, will I now say because the court granted me bail in a charge of stealing, then I should be a free man? You have decided to commit multiple offenses, so you should face the offenses. You should answer for those offenses.
Yeah, but from the side of the government, the point there is that we are not seeing a deliberate move to charge him to court on the
like
other
Olisa.
issues you're talking about. If there are other issues,
Like Olisa,
we've not seen all of those.
Like, which of the issues that are we talking
You
about?
mentioned the issues.
You
so
said there could be other issues.
There is illegal possession of firearms.
So we're asking, why are they not pushing this case?
I want to believe that matter is in court already. There is the 2.1 billion armed probe. There are countless other criminal allegations against him that there have been charges before the court. The bail application has not been heard. Some of them bail were actually denied. So what are we talking about?
How about El Zakzaki? I'm surprised you're not aware of him being asked to let go, to be.
Well, he's been arraigned now.
You see, El Zakzaki has been arraigned. Yeah. So I don't know what we are talking about again. And you see, offenses varies in Nigeria. There are some offenses that are regarded as simple offenses, misdemeanor. There are some offenses are felonious. What Ezazaki was alleged to have done has tremendous security implication on the sovereignty of Nigeria. So it is something that the government, any government that knows its onions, any government that knows its what, needs to undo very carefully. There are insinuations that there are some form of link with a certain Islamic sect in Iraq or Iran. Or thereabout. Yeah, it's a very serious security issue. These are a set of people that will block the road. Even, I mean, we read that the former vice president had to turn around in a country that has law and with the kind of supporter he has. So sometimes the president, because he has so much security information than you and I, we know what to do in certain circumstances to prevent a total breakdown of law and order. Because what we are talking about, the courts will not even be there any longer. The courts will be raised down, people will die, people will lose their lives. And so the president understanding the total security implications of releasing someone to the society. And that was why they came up at some point that, look, he's in protective custody. He's been charged to court now, and I believe he will have his day in court.
Okay, well, let's leave this one for now. Wale Faponda, thank you so much for coming on the program.
It's nice.
Appreciate your time.
Right. Okay.
Well, attacks by suspected headers.
I think we have to go on a break first.
Yeah, but we'll talk about that when we come back. Stay with us. You're watching
All right.
The Breakfast Show.